Welcome back again. Listen carefully, because what's unfolding right now is something almost unheard of in American legal history. A former First Lady of the United States is on the verge of being compelled to testify under oath about deeply personal matters: her marriage, her residence, her tax filings, and her ties to Jeffrey Epstein. Not in a memoir, not in a media interview, not through leaks, but in federal court, with the weight of perjury hanging over every word. That First Lady is Melania Trump. And here's why this moment is extraordinary. It isn't the product of partisan attacks, opposition research, or speculative reporting. It is the direct outcome of a legal move made by Melania Trump and her own attorneys. A miscalculation so severe that it stripped away the protective veil powerful families usually rely on to keep their private lives hidden. Right now, a federal judge is overseeing a case that raises questions no First Lady has ever had to answer in court. Where does she actually live? Where does she spend most nights? What do her tax filings reveal? Which state does she claim as her legal residence? And if those filings don't align with reality, which version of the truth has she been presenting under oath? This case didn't begin as a sweeping constitutional battle. It started the way so many Trump-related legal fights do, with a threat. A colossal threat meant to silence a journalist, intimidate a critic, and kill a story before it spread. The price tag attached? $1 billion. But instead of retreating, the journalist did something almost no one dares to do. He fought back. He filed suit first. And in doing so, he maneuvered Melania Trump into a legal trap that even a sympathetic judge may struggle to undo. The implications reach far beyond one family. This case forces us to confront a dangerous but fundamental question. What happens when the most powerful are finally held to the same legal standards as everyone else? And here's the twist. This didn't start in a courtroom. It began with a letter, the kind of letter that has long terrified journalists, publishers, and media companies into silence. In October, veteran investigative reporter Michael Wolff received one of the most aggressive demand letters imaginable. It accused him of defamation and threatened a lawsuit seeking damages of $1 billion. Not millions, $1 billion. The message was crystal clear. Retract everything you've written about Melania Trump's ties to Jeffrey Epstein. Issue a public apology or face financial ruin. That letter came from Alejandro Breto, a Florida attorney who has quietly become a key legal enforcer within Donald Trump's circle. This is the Trump legal strategy distilled to its essence. Don't argue facts, don't debate evidence, bury your opponent under the crushing weight of litigation costs and dare them to survive. And most of the time, it works. Targets fold. They issue humiliating retractions, but not this time. Most journalists hit with billion-dollar threats either cave, issue what Michael Wolff once mocked as forced confessions, or simply disappear until the storm passes. That's why this case is uniquely dangerous for the Trumps. Wolff isn't a blogger or a casual commentator. He's a seasoned investigative reporter who has already endured years of legal intimidation and walked away intact. He's published best-selling books exposing dysfunction inside the Trump White House, stories Trump himself wanted buried. So when Wolff received that demand letter, he didn't flinch. He didn't apologize. He didn't retreat. He went on the offensive. And that single move transformed a routine intimidation tactic into a full-blown legal crisis for Melania Trump. What happened next is the moment this fight went nuclear. Instead of waiting to be dragged into court under the crushing weight of a billion-dollar lawsuit, Wolff flipped the script. He filed first, taking his case straight to New York State Supreme Court. That kind of preemptive strike is almost unheard of in modern media law. It was a calculated gamble designed to drag the dispute into the open. In his filing, Wolff didn't hedge or soften his words. He laid out every statement Melania Trump's lawyers labeled defamatory and dismantled them one by one, methodically and publicly. He showed that each claim was either factually supported, clearly protected opinion under the First Amendment, or deliberately twisted out of context by Melania's legal team to appear more scandalous than it was. But Wolff didn't stop there. He escalated. He accused Melania Trump and her attorneys of weaponizing what legal experts call slap suits, strategic lawsuits against public participation. These aren't designed to win on evidence. They're designed to bleed critics dry, scare them into silence, and warn others not to speak out. By suing first, Wolff forced Melania Trump into the one arena she has spent her public life avoiding: discovery, deadlines, judges, sworn testimony. This was no longer a shadow war fought through threats. It was a live legal battle governed by rules and constitutional protections. The moment Wolff filed, the Trump legal machine lost its most powerful weapon: fear. That's when Melania Trump's lawyers made the move that would change everything. On paper, it looked clever. Instead of fighting in New York State court, they tried to shift the case into federal court. It's a common tactic in high-stakes litigation. Federal courts operate under different rules, and defendants often believe federal judges are more restrained than state juries. But here, there was another layer. By random assignment, the case landed before Mary Kay Vissel, a federal judge appointed by Donald Trump himself. To the Trump team, this must have felt like regaining control. A familiar judge, a federal forum, a chance to shut the case down quietly. For a moment, it probably looked like the gamble had worked. But here's what most people don't realize about federal court. You don't get there just because you want to. Preference isn't enough. Jurisdiction is a strict requirement. If you can't legally justify being in federal court, the case collapses back to state court. Worse, the attempt itself can pry open doors that were previously sealed. By choosing federal court, Melania Trump's legal team stepped directly onto a procedural landmine hidden in the rules of civil litigation. This is the point where Melania Trump's legal maneuver transforms from risky to catastrophic. Federal court operates under a rule that is blind to politics, blind to appointments, and blind to influence. It demands proof. And the proof her team must now provide comes at a devastating personal cost. The mechanism they invoked is called diversity jurisdiction. It's brutally simple. Federal courts can only hear civil cases if the parties are residents of different states. If both sides live in the same state, the federal court has no authority, no discretion, no loopholes. The case is sent back to state court. Michael Wolff's residency in New York is undisputed, which means Melania Trump must prove she is not a New York resident. Not suggest, not imply, prove. By attempting to move the case into federal court, her attorneys triggered a procedural trap. Once residency is challenged, the opposing side gains the right to jurisdictional discovery. That means Wolff's lawyers can demand documents, interrogatories, subpoenas, and sworn testimony, all focused on one question. Where does Melania Trump actually live? Not where she claims to live, not where press releases say she lives, but where she physically resides. And once that process begins, it cannot be stopped halfway. Jurisdictional discovery is not optional. It is mandatory, and it gives Wolff's team extraordinary power to pry into her private life. They can question her under oath about where she sleeps most nights, which address she uses, how often she stays at Trump Tower versus Mar-a-Lago, and when she last shared a residence with her husband. These aren't tabloid questions. They are legally relevant to establishing domicile. They can also demand her tax returns, both federal and state. Those records don't bend to public narratives or political spin. They reveal in black and white where she has claimed residency and whether those claims align with reality. By chasing what looked like a safer courtroom, Melania Trump's legal team activated the one procedural mechanism that strips away the privacy shield former first ladies have always relied on. And now, for the first time in American history, a first lady faces the prospect of answering the most intimate questions of her personal life under oath, with no privilege, no exceptions, and no escape. Residency declarations are not symbolic. They are binding statements made under penalty of law. If Melania Trump has claimed Florida residency for tax benefits while spending most of her time in New York, that contradiction becomes legally explosive. Wolff's attorneys can demand property records, utility bills, credit card statements, travel logs, even grocery receipts and medical appointments, anything that reveals the rhythms of daily life. Residency is proven through habits, not headlines. And here's the trap her legal team cannot sidestep. Every answer must align. Tax filings, prior statements, state-level benefits, all must be consistent. Any discrepancy isn't just embarrassing, it's dangerous. False testimony is potential perjury, and even omissions can unravel once documents contradict sworn statements. This is why jurisdictional discovery terrifies powerful defendants. It strips away image control, replaces spin with hard records, and forces denials into sworn answers. Melania Trump walked straight into that process. What began as a defamation threat has now evolved into a forensic audit of her private life. And one detail threatens to shatter her residency argument entirely: her son. Barron Trump's enrollment at New York University places residency under a microscope. Universities don't casually ask where a student lives. They require formal residency declarations with financial consequences. In-state versus out-of-state tuition classifications hinge on explicit documentation: addresses, parental domicile, tax information. That leads to the unavoidable question: what residency was claimed for Barron Trump on his NYU paperwork? If the family declared New York residency to secure in-state tuition, it directly undermines Melania's claim of Florida residency in federal court. The law doesn't allow convenience-based residency. You cannot be a Florida resident for jurisdiction while simultaneously representing yourself as a New York resident to a university. and the complications deepen. If Melania argues Barron lives in New York independently while she resides in Florida, it raises new questions. Why would a minor child live full-time in Manhattan while his mother claims to live elsewhere? Who supervises him? Where is the primary household? Where are the daily routines anchored? Residency is not about mailing addresses. It is about the center of life, where obligations are met and family life is rooted. For years, reporting has consistently placed Melania Trump in Manhattan, shopping, attending appointments, maintaining a visible routine. Those patterns now collide with her legal claims, and under oath, every contradiction becomes a liability. Proximity to Barron has always been the explanation for Melania Trump's presence in New York. Now, that same reasoning threatens to unravel her entire legal strategy. If she resides in Manhattan to remain close to her son, federal jurisdiction collapses, and the discovery process that proves it becomes part of the public record. Barron Trump is not a party to this case, but his enrollment in New York may be the single fact that makes Melania's federal court gamble impossible to sustain. Here lies the most damaging irony. Even if she somehow navigated jurisdictional discovery without devastating consequences, even if every residency question broke in her favor, the defamation claim itself is astonishingly weak. U.S. defamation law sets an extraordinarily high bar for public figures. And Melania Trump is not just a public figure. She is a former First Lady. To prevail, she must prove Wolf knowingly published false statements of fact or acted with reckless disregard for the truth, and that those statements caused measurable harm. Opinion is protected, context matters, documented reporting is shielded. Look closely at the statements her lawyers targeted. Wolf wrote that Melania had ties to Epstein's social world, supported by public records of modeling agencies, social circles, and historical overlaps. He suggested she may represent a missing link in Trump's relationship with Epstein, clearly framed as analysis, not provable fact. He referenced modeling networks with documented connections to both Trump and Epstein. None of this is reckless invention. None of it is rumor. It is contextual reporting layered with interpretation, the very type of speech the First Amendment protects. Which raises the unavoidable question, why take this risk at all? Why expose residency, taxes, marriage, and private life to sworn scrutiny in federal court to pursue a claim unlikely to survive summary judgment? Legal experts quietly call this malpractice territory. Someone should have stopped it. Someone should have explained the cost-benefit calculus. Instead, Melania pressed forward and now faces the most invasive legal exposure of her life for a case that may collapse before trial. At this stage, the danger is not the question she will be asked. It is that there is no clean exit. Every option carries severe consequences. She could abandon the federal court attempt and return to New York State court, but that would mean publicly admitting the removal was a mistake, a miscalculation that triggered uncontrollable discovery. Retreat of that kind is rare in high-profile litigation and invites even more scrutiny. Settlement is another theoretical option, but that door appears closed. Wolf did not sue first to compromise. He sued to force transparency, to set precedent, and to put the intimidation strategy itself on trial. Settling would rob him of the discovery that makes this case matter. Her team could try to limit discovery, arguing that questions about her private life are overly intrusive. But once jurisdictional discovery is triggered, the scope is not defined by comfort. It is defined by law, and the law demands answers. Federal procedural rules leave no room for improvisation when jurisdiction is challenged. If residency is legitimately disputed, discovery isn't optional. It must proceed. Judges cannot bend those requirements out of sympathy or political loyalty. That means the most likely outcome is straightforward. The case moves forward, discovery begins, depositions are scheduled, and Melania Trump sits under oath answering direct questions about where she lives, where she sleeps, how often she is in New York versus Florida, and what her financial and tax records reveal. Once those answers are given, they don't vanish. They are transcribed, preserved, and become part of the litigation record, accessible to journalists, investigators, and anyone comparing them against prior statements or filings. For a family built on controlling narrative, this is the nightmare scenario. Donald Trump has long wielded litigation as a weapon to silence critics, but this time the tactic backfired. The very machinery designed to suppress information is now forcing it into the open. For Melania Trump, the countdown isn't toward victory. It's toward testimony. And when you zoom out, the significance extends far beyond one lawsuit or one former First Lady. This case exposes the fundamental weakness in the Trump legal strategy. It only works if no one fights back, threaten lawsuits, inflate damages, intimidate critics, drain them financially. Most people fold before a judge ever sees the case. That cycle kept facts untested, documents hidden, and sworn answers avoided. Michael Wolff broke that cycle. By suing first, he forced Melania Trump into the one arena the Trump orbit has always tried to avoid, a courtroom governed by rules, not leverage. In that arena, power doesn't come from intimidation or money. It comes from evidence, consistency, and truth. For Donald Trump, this is the nightmare. Not because the defamation claims are strong, they aren't. Not because the judge is hostile, she isn't. But because discovery is indifferent to politics. It cares only about facts. Where do you live? What do your records show? Do your statements match your filings? Those questions cannot be spun, tweeted away, or buried under threats. If Melania Trump testifies, her answers become part of the permanent record. If documents contradict those answers, the fallout escalates instantly. What began as a defamation dispute morphs into a credibility crisis, potentially a tax issue, potentially something worse. And that's why this moment matters. For journalists who've been silenced, for whistleblowers warned the cost of speaking was too high, for citizens taught the powerful never face accountability, this case proves the opposite. When intimidation fails, the system flips. The rules apply. The truth is demanded under oath. Melania Trump didn't intend to create this moment, but she did. Through one strategic mistake, she opened the door. Discovery is beginning. Depositions are coming. Documents will be produced. And once sworn testimony starts, there is no rewind. This is no longer speculation. It is accountability unfolding in real time.